Welcome to this explainer. Today, we're diving into a massive compliance shift that's about to hit educational institutes all across India. We're talking about the new Digital Personal Data Protection Act, or DPDP. If you're a school principal, a trustee, or an administrator, listen up, because your daily operations are about to change fundamentally.
Okay, let's kick things off with a pretty chilling reality check straight from the legislation itself. It says, education is the single largest collector of children's data in India, and DPDP makes that the highest risk activity under the Act. Just think about that for a second. You handle student names, photos, medical records, parent contacts every single day. Under this new law, that routine data collection puts your institution right at the absolute center of regulatory scrutiny.
So here's our roadmap for today to help you secure your campus. We're going to cover 1. The new privacy reality. 2. Everyday school data risks. 3. The 250 crore threat. 4. Your compliance playbook. And 5. Taking the next step.
Let's jump into Part 1, the new privacy reality and the DPDP context.
So why exactly are schools suddenly in the crosshairs? Well, under the DPDP Act, a child is defined as anyone under 18 years of age. That means almost every K-12 student and even a lot of junior college learners fall perfectly into this ultra-protected category. You aren't just processing standard user data anymore. You're processing the highly sensitive data of minors.
And because you're handling minors, Section 9 of the Act drops some incredibly strict obligations on your plate, totally changing the game. You can't just casually collect data anymore. Verifiable parental consent is now absolutely mandatory before you do anything. On top of that, tracking and profiling children is strictly banned. That means you've got to disable third-party trackers, behavioral analytics, and targeted ads on any student-facing apps or websites you run. It is a massive, fundamental shift in how educational platforms are allowed to operate.
Moving on to Part 2, everyday school data risks. Let's look at the real DPDP risks.
What's really wild about this is how these regulations totally upend your daily operations. Think about the real risks happening today right inside your institute. Open Excel fee lists being passed around among staff. Class event photos getting posted on WhatsApp parent groups without explicit, documented consent. Or taking parent phone numbers to push fundraising or edtech pitches. Under the new law, those aren't just bad habits anymore. They are severe compliance breaches.
Now here's another huge blind spot we need to talk about: vendor leakage. Think about your transport contractors, your canteen vendors, ed tech partners, or those school photographers. They usually get full student lists, right? Often with zero formal contracts in place. Well, under DPDP, you remain entirely responsible for that student data. If a vendor leaks it, you are the one paying the price.
This really hits home when you compare old school consent with the new requirement for verifiable parental consent. Old school consent was so easy, just a bundled tick box on a paper admission form, or assuming someone opted in because they joined a school WhatsApp group. Yeah, that simply won't fly anymore. Verifiable parental consent demands unambiguous affirmative action. We're talking about signed forms with parent ID proof, OTP confirmations sent to their phones, video KYC during enrollment, or digital signatures using DigiLocker. Consent has to be a provable, undeniable choice now.
Which brings us to Section 3, the 250 crore threat. Let's talk about the DPDP penalties. Let's get right to the bottom line, and honestly, this is a boardroom-level existential threat. 200 crore rupees. That is the maximum penalty your school faces just for a single children's data violation. Because the vast majority of your data subjects are minors, this is your absolute biggest exposure as an administrator. Just mishandling verifiable consent or tracking a student app could trigger this catastrophic fine.
And somehow, it gets worse. 250 crore rupees. If you fail to implement reasonable security safeguards to protect that personal data, like, say, failing to encrypt a teacher's laptop or leaving a cloud drive full of admissions documents open to the web, the fines can reach up to a staggering 250 crore rupees. These are not slap-on-the-wrist warnings, folks. These are institution-ending penalties designed specifically to force compliance.
Okay, take a deep breath. We're pivoting to Section 4, your compliance playbook. Let's map out exactly what institutes must do.
Your absolute first line of defense is creating a living register called a ROPA, or a Record of Processing Activities. You need this for every single piece of student, parent, and staff data you hold. You have to meticulously document exactly what data is collected, like medical records or test marks, why you're collecting it, where you store it, who you share it with, how long you're going to retain it, and crucially, which controls are actually protecting it. This document is essentially the foundational map of your data perimeter.
Next, we've got to talk about incident response. If a breach happens, say a teacher's laptop gets lost with unencrypted class lists, or a misconfigured Google Drive exposes a bunch of other cards, sweeping it under the rug is not an option. You are legally required to execute a specific 5-step response protocol fast.
Let's break down those 5 steps. 1. Contain the breach immediately by isolating the system and revoking credentials. 2. Assess the situation to determine the exact scope of the data exposure. 3. Notify parents. You have to inform the affected families in clear, everyday language. 4. Notify the board. Yes, you have to report the incident directly to the Data Protection Board. And 5. Remediate the issue by fixing the root cause and updating your controls. And keep in mind, failing to follow these exact steps to report a breach is actually a separate violation that carries its own massive penalty.
So how do we stop a breach before it even starts? Here's your 90-day operational hygiene and security checklist. You need to encrypt staff laptops and strictly limit file sharing so data stays locked inside your walls. Enforce strong role-based access in your ERP system. Teachers shouldn't be seeing fee data, and admins don't need access to sensitive medical records. Enable multi-factor authentication for all admins and vendors. Maintain tested offline encrypted backups away from your main network so you can actually survive a ransomware attack. And finally, roll out a self-service parent portal so they can easily exercise their rights to view, correct, or erase their family's data.
All right, finally, Section 5. Taking the next step to secure your campus.
You know the stakes now, so let's talk about real-world execution. Educational institutes absolutely must take this seriously starting right now. Navigating these strict regulations isn't a DIY project. It requires specialized tools built specifically for education. Your best next step is reaching out to Himanshu Modi over at Sujal Technologies and Siccura Limited. They specialize in DPDP-aligned solutions. Tools like the Sums ERP platform to securely manage your operations, and Siccura Regula, which provides crucial file-level encryption that literally follows your data wherever it goes.
I'm going to leave you with a really critical question to chew on at your next board meeting. If the Data Protection Board showed up tomorrow and audited your school's WhatsApp groups, your open Excel files, and your vendor lists, would your doors stay open? It's a huge wake-up call. It's time to take action and truly protect your students' data. Thanks so much for joining this explainer, and we'll catch you next time.